motion, item 1.
Your Lordship, this matter pertains to challenge to impugn notification banning the petitioner to participate in all activities of football within the state and outside the state. In fact, it is throughout the country. So the petitioner, except 1 and 2, are professional football players.
Where is the order?
Order is at Your Lordship, Annexure 4, it starts from 51.
Page 51.
Yes, if you kindly see 50, it was making the list.
Okay.
50.
How many petitioners?
Actually, Your Lordship, I represent Sipir Venglun Football Club and their players and coach and the president. And the impugn notification start from, it's at Annexure 4. Petitioners 10.
10 petitioners. Page 50 is the list.
50 is the list,
List. Okay. Petitioners
including the others, another clubs and players.
Okay. So tell me, who are the petitioners in page 50?
My Lord, I can say serial number 1, club Sipir Venglun FC, and that table number 1, Robert Laldintara, and in the third table, those serial number 3 to 16. Your Lordship, my main challenge is
Before that, just a minute. Petitioner number 1 is Mr. Laltlanmo Asilo.
Yes.
Where is his name in this list?
My Lord, actually, he is the president of the football club.
Maybe.
And
But-
also,
but
here
this
if you
list-
see, yes, Your Lordship, if you see 51, this is the president.
Oh, he may be president, prime minister, whatever, it's okay.
Yes, Your Lordship.
What I want to know is where is his name in the list?
My Lord, because whenever they address, they just address as the president.
So this list is not good for nothing.
Yes. So it starts from, the order is from
Doesn't make any sense with your list.
Annexure 4.
So, page 51, who's this?
Annexure 4, this is the president. The petitioner number 1.
He's the petition number 1.
Yes, and number 2 is the petitioner number 2. They have approached this honorable court, all of them, by name, by name.
52 is petition number 2.
Yes.
Then
53, petitioner number 3.
Chandra.
Yes.
Okay, then?
Your Lordship, it keep going on like that.
Yes, let us finish it.
Yes.
There are only 10 of them. It's
Yes,
not
yes.
100, 200 like that.
Sure.
Then
Then next,
this is number 4.
yes, Salin,
Then 55,
yes,
this is petition number?
4.
No.
I think,
55 is petition number
my
5.
Lord, in my petition, I have made table ways for easier understanding.
That is why I'm asking you, where is the table? You're showing me some table where the name doesn't exist.
My Lord, if you
So
see,
let us go one by one of
yes,
all these
my Lord,
pages.
if you see this one, page number 6, I have classified as table in my petition.
Okay, just a minute.
Para number 3. Page number 6.
Petition number 6, then I want to go to the individual pages. Laos Roizela is petition number 7.
Daltroizela 7.
Then
Liensang Lura 8. Muansanga 9. Malsom Klonga 10. Lalram Lua 11.
oh, there are 11 of them.
Yes, that's it. If you kindly see page number 6 of my petition, it is very clear with their punishment. Page number 6.
So what are these things? Page number 51 to 61.
Yes.
What are they?
One is the president of the club.
This is the impugn order.
Yes,
Please read one of the impugn orders.
Lordship. I'll read the 51.
Yes, read.
To the President, subject violations of Article 63.2 of the AIFF Code, Disciplinary Code 2024, the Code. The letter will confirm our decision over a charge of corruption and penalty by your recent performance during 11 MPL League, which was held from 9/7/2024 to 15/10/2024, in which you were taking part in the corrupt practices described by Article 63.2 of the AIFF Code 2024. Article 63.2, anyone who solicits or accepts an unjustified advantage from an individual seeking to incite violations of AIFF, regulating or to obtain any other improper advantage, regardless of whether that advantage materialized, has committed an offense. Penalty: fine of at least rupees 3 lakhs and a ban on taking part in any football-related activities for at least 3 years and a ban on entering any stadium. After careful review of your performance, the MFA Disciplinary Committee has observed that your performances have been unsatisfactorily and not up to the standards agreed upon at football clubs. In the light of the above-mentioned charge, you are hereby charged of violating Article 63.2 of the AIFF Code 2024, and the penalty is banned on taking part in any football-related activities for a period of 3 years. Time period is between 4/11/2024 to 2028 to 2029 seasons. The security deposit for the MPL League 11 will also be charged as a fine for violations of the code. The MFA will take part this issue to ensure that this penalty is not only enforced within Mizoram, but throughout the entirety of India, whenever the jurisdiction of AIFF applies. You are hereby informed that appeal against the penalty can be lodged to the MFA Executive Committee through Honorary Secretary before the lapse of 10 days on issue of this letter. They are all same.
Let me ask you a question, okay?
Your Lordship, yes.
Please answer me accordingly. This is the penalty
Yes.
passed by the disciplinary committee.
Yes, Lordship.
Prior to passing this order,
Yes.
was there any show cause notice or anything like that?
No, not at all.
Any chance?
We are called on 29/10.
2910.
Yeah, 29/10 to appear before them.
Okay.
So this is at
Any letter like that?
47.
Any personal, any letter given to you for appearance?
Letter was given to the petitioner number 2. They inform all of them to inform them.
Okay. Where's the letter? Is it
It is
here?
at 47, Your Lordship.
47. Yes. Please read.
To someone to appear before MFA Disciplinary Committee. Dear colleague, you are accused of violating AIFF Code. You are hereby called to contest and plead on your behalf on 10/15/30/10/2024 Wednesday at MFA office.
Okay.
If you do not appear on the time mentioned above, your case will be heard and decided by MFA Disciplinary Committee in your absence. Lordship, very important here is that he was informed, the petition number 2 coach was informed, and they informed him to tell others, because, Your Lordship,
Number 2 is coach.
Coach.
He's the coach.
Yes. You see, one Tamang is from Sikkim, and one Sailen is from Manipur. How can they appear within these 2 days before them? They did not appear, and they are given very harsh punishment, 5 years. Those who do not appear before them,
5 years or 3 years?
5 years.
I thought you read
No,
3 years.
if you see the table, 5 years. If you see page number 6.
No, you just read the impugn order.
No, the coach was given 3 years. What I stress is that because 2 of them are outside Mizoram, one is in
Okay.
Sikkim, one is in Manipur.
Okay, penalty is not similar.
Yes, 3 and 4, just because that they do not appear
Who
on
is 3,
30th.
who is 5? Tell me.
Lordship,
Who is given 3 years?
by the MFA,
No.
disciplinary.
Who are the petitioners who are given 3 years ban?
Yeah, I'll petitioner 1, 3, and between 6 and the rest, all of them, 6 to 11. 1, 6 to 11.
Petition number 1,
and 6 to 11.
then 6 to 11.
Yes.
They are given 3 years.
Yeah, the rest 5 years. Just because they don't appear before them. To this, they can't appear.
Those who appeared, they were given 3 years.
Yes, like
Those
that.
who did not appear, 5 years.
Yeah, that's simply like that.
Okay.
Actually, they have, in my pleading, I have pleaded that they have already the form. Those who sign, they have given 3 years. Those who do not sign that thing, they have given 1 year.
Sign what?
Sign, there is some undertaking.
Undertaking.
That's why that undertaking was extracted from the police station, Aizawl PS. That's why you have come. Because they have been called at police station whole night and whole day.
Okay. What is this Article 63.2?
Your Lordship, I have the AIFF code here, the book with me.
No, it's abstracted here also.
Yeah, I have accepted, but yeah, this is the code. If you Lordship want to...
It is abstracted in the impugn order itself, isn't it?
Exactly. But if you see, this should be penalty for a player. This should not be a penalty for the club. Because
AIFF means All India Football Federation. Okay.
Your Lordship, if you see football player, if they penalize, they are reduced in the table normally, and they reduce their points. But if you see the language itself, anyone, and that is the punishment, the punishments are all same except the years of the punishment. Actually, in fact, the club has not been penalized at all. The Superior Football Club. This penalty is for a particular person. And my Lord, since after that, if you can...
there was a letter summoning you to appear on 31st of October 24.
Yes.
And pursuant to that, this impugn order has been given.
Yes.
Under 63.2.
Yes.
This particular, what do you call, article?
Yes.
What do you call it? Article of...
Article 63.2.
This is a disciplinary code.
Yes.
What is the kind of punishment given here, penalty given there?
This is this one.
What is the penalty? Ban?
Ban.
For 3 years or 5 years?
Yes.
What is the minimum and what is the maximum?
My Lord, here they have written that 3 years. If you kindly see this, the code 63.
You must have already gone through it.
No, my Lord. They just copy paste from the code. It is 3 years.
I'm talking about you. You must have read it yourself.
Yes. 3 years. 3 years.
So can you just tell me what is the minimum and what is the maximum penalty?
My Lord, 3 years and lifetime also they can impose.
3 years is the minimum.
My Lord, as per 62, it is 3 years is minimum.
Okay, that's what I'm asking you. 3 years is the minimum, and it can extend to lifetime also.
Definitely, yes. Because two of them...
To impose that penalty, what are the requisites?
My Lord...
Any show cause, any
yes,
personal
that's
hearing?
what I would like to...
Show me the provision there.
No, I have said it too. Section 2.
Mr. JC.
Section 2.
See, don't be excited about your submissions. I want you to be meticulous. I'm asking you, prior to issuance or prior to punishing anybody under this disciplinary thing, code,
yes,
what are the requisites? What is to be done? Show cause notice, personal hearing, what all is to be done?
My Lord, they have...
And after, just a minute, after punishing that person, what is the provision thereafter? Any review, revision, appeal? You tell me those provisions.
Yes, Section 6 is the provision as part this one. I have clearly highlighted in page number 24 of my paper.
Section 6 is the appeal?
Section 6, yes.
Did you prefer an appeal?
No, Section 6 is procedures for AIFF for disciplinary committee.
Where is that?
If you see 24 of my petition, it is, I have highlighted.
Page 24?
24.
Yes.
This is the process, and I have copy-paste from the code. Section 6 is the procedures to be adopted by AIFF.
Don't say copy-paste. You say I have abstracted it.
I beg your pardon.
Copy-paste is a very, it's a terminology which is not very on the positive side.
Yes.
Copy-paste. You see, I've abstracted it from there. Okay. So, page 24.
Yes.
So, what is violated here?
My Lord,
If they have given you a chance of hearing,
my main case is that MFA is not the authorized authority to impose this penalty as per the code. It should be AIFF disciplinary committee.
Where is that?
My
Show
Lord,
me.
because
Where is the
here,
provision?
this is
No, don't keep on submitting. Just show me the provision.
section 6. First, section 6 is, may I kindly read?
You just give me the section, that's all.
Yes, section
Under
6.
section so and so,
Section
it is,
6.
it is the AIFF who can punish
Yes, section
or who can
6.
impose penalty.
Section 6. Yeah, procedures rule to adopt by AIFF disciplinary code.
But this, whatever you call it, what is this? They are they not affiliated?
They are affiliated, but there is no delegations of power to MFA.
Respondent number 5,
Yes,
MFA.
yes,
They are affiliated to the AIFF.
yes,
So something happens like this, something like this happens.
yes,
Then what happens? Are they supposed to refer it to the AIFF?
that it should be.
Under what provision?
My Lord, actually, this law itself, the code itself is the code made by AIFF. The only authority to penalize the professional player is only AIFF, as per
Okay.
section 6.
Okay, then you tell me, in your
Yes.
case, you are a football association.
Yes.
Something happens within your association, then what kind of steps can you take?
Because recently only they have their own code. Recently, because of this incident, that 2025 code was recently established. Because prior to that, we should be under this 2024 AIFF code. Very detailed, how proceeding has to be initiated. There should be hearing, there should be intention to appeal, there should be representation, evidence should be taken, everything, it is there in section 6. They have not adopted at all by MFA, disciplinary committee. They just call on 31st, they ask some question, give penalty, that's it.
Petitioners all belong to one particular football club.
Yes, Lordship.
They are all from CP Ranglun Football Club.
They are from CP Ranglun Club, they are player of CP Ranglun Club.
And they are affiliated, they are registered under the Mizoram Football Association.
Yes, Lordship, they are the
And in turn, MFA is affiliated to the All India Football
yes,
Federation.
Lordship.
And MFA does not have its own sort of
Power.
code or
Yes.
what do you call the procedure
Yes.
to
They just,
proceed in disciplinary cases.
they just follow AIFF code. If they follow AIFF code, they have to follow the procedures enshrined in that code.
So what is
code.
the procedure? Section 6.
Yeah, section 6. Disciplinary procedures, this is the procedures. 114, commencement. And disciplinary proceeding may be opened by AIFF administration and ex officio on the basis of the report where a protest has been lodged in accordance with relevant competition regulation at the request of AIFF President, AIFF Executive Committee or Secretary on the basis of the comment received from the public authority where a complaint has been filed. Any person or body may report any conduct considered incompetent with AIFF regulation. Such complaints have been making in writing. Match officials are obliged to report infringements which have been come to their notice, and there will be investigation. Prior to opening of disciplinary proceeding, Secretariat shall carry out necessary preliminary investigation, ex officio on the basis of information received from Article 114. If Secretariat deems that there is no prima facie case, it may close preliminary investigation without opening disciplinary proceeding. If the Secretariat deems that there is a prima facie case, it shall open disciplinary proceeding. Secretariat may offer an administrative resolution with party prior to the opening of disciplinary proceeding and subject to the relevant competition regulation. If accepted by the party, such administrative resolution must be subsequently approved by the chairperson or by any member designated by the chairperson recorded by the AIFF. Should the chairperson not approve administrative resolution, disciplinary proceedings shall be opened. Secretariat shall have the power to hire or appoint external resources to assist any investigation. The Secretariat shall inform the party that disciplinary proceedings have been opened. Once the investigation has been completed, the Secretariat deemed that there is a case, it shall follow the charges of misconduct and full case to file to the party and provide the party with opportunity to be heard. The content of the full case file may be restricted in accordance with Article 91. Once the investigation has been completed, the Secretariat deems that there is no case, disciplinary proceeding shall be closed. Disciplinary proceeding may be closed if, among other things, the party reaches an agreement or the party declares bankruptcy. If disciplinary proceedings have been closed, Secretariat may reopen investigation if new facts or evidence are discovered within limitation period for prosecution. Secretary or Deputy Secretary shall prosecute the case on behalf of AIFF before AIFF Disciplinary Committee. Secretariat shall have the authority to hire or appoint external counsel to prosecute the case on behalf of the court. Actually, they just simply make in their penalty at the last line, you prefer an appeal. There is no separate provision to be followed by MFA.
Okay, so have you filed an appeal?
Still we file.
You have filed?
Yes, still we file.
Where is it?
62, Your Lordship.
There are so many 62s.
Page number 62.
Huh?
Yeah, 62. Actually, in fact, this matter was...
What kind of numbering is this? You put 62, then you put again another number,
No, actually,
46,
this matter
and
was-
below there's another number, 47.
This matter was listed before Justice Marley once, and we had full hearing. That time, that she was inclined to pass order for deciding the appeal within time frame to the disposition authority. When she checked it, she found that full, complete set of appeal was not there. So if you see the first order also, and we are directed to include full copy. That's why we make 63.1, 63.2.
Oh. And in that bargain, you have confused everybody now.
No, my lord,
There's so many 62s, I don't know.
62.1,
which particular 62?
62.2.
Huh?
62.1, 60.2. It keeps going on, not to disturb another pagination.
No, please come to page 62, an extra 5.
Yes,
The first 62.
yes.
Then when you turn the page, it becomes 62 within bracket 37.
My lord, 62 inside bracket 1.
Inside bracket 37. And below bracket 38. 3 numbers are there. So when you say any page number, then we cannot
My
turn
lord,
the page.
in our copy, it is 63 bracket 1.
So you should take due care that your copy and my copy is same.
Is it same?
Your copy is different, my copy is different. You should have done one thing. You should have withdrawn the writ petition and filed afresh
My lord,
with proper numbering.
my lord, this is acceptable, lordship.
Acceptable to whom? To
My
you.
lord,
Suppose I reject it, then
my lord, actually...
you
just
accepting will not make any sense.
No, it's true, lordship, I understand.
Then how do you say it's acceptable? Simply like that. You correct the pagination. We'll list it again some other day. There is some discrepancies here. Please check it up
My lord,
properly.
actually, when we inquire in the registry, they accepted. That's why I say that it is acceptable. That's why.
But I don't accept it.
It's fine.
Shall I make an order?
No, my lord.
If you insist, I will make an order.
My lord, I don't insist. I don't insist, lordship.
I'll dismiss it with liberty for you to file afresh.
My lord, please,
That'll be better.
we'll rectify it, lordship.
Then you don't make such kind of statements. Who is for the other side? You please examine whether writ petition is maintainable or not.
I have just received a copy this morning.
Oh, whatever. So we're not taking up now. Please try to understand what I'm telling you. Examine whether a writ will lie or not in such a case. This aspect of the matter you should look at. You don't require to obtain instructions on that. On your own, you can make your study and find out. And don't just plainly say issue notice. You should first see whether is it worth issuing notice or not. Not only in this case, any case. You see, there's no fun in just issuing notice. You can check it up on your own whether notice should be issued or not. If notice is not to be issued, you can simply say this is not maintainable. Court may dismiss it at the motion stage. This kind of study is required. You should assist the court. All right. Not only you, I'm telling all your colleagues also, they should examine properly. You should also satisfy, whether this association or will be within the ambit of your grievances against the respondent number 6,
Yes.
perhaps.
Yes.
So whether respondent 6 can be termed as a state within the meaning of Article 12 of the Constitution of India. This also has to be looked into.
Yes, Lordship.
Anyway, next.
Orders, item 7.
Please list the matter again after a week. In the meantime, the Learned Counsel for the petitioner shall make a necessary rectification in the pagination of the writ petition. Yes.
My Lord, as per your Lordship's direction, I have submitted a certified true copy of the written objection submitted in execution case number 22 of 2020. And my Lord, if your Lordship could kindly come to page number 3. Page
Yes.
number 3 in the last paragraph.
Yes, yes.
If I may read, my Lord. The judgment debtor's wife, Smith Lal Thutlung Liani, and daughter Smith Lal Khumtiri went
What
to the...
Smith?
Srimati, ma'am.
Don't invent your own word Smith like that.
My Lord. Went to the house of the
Then what will
decree.
you call MR then? You'll call Mr.
No, my Lord.
Don't make your own thing.
My Lord.
If you don't want to pronounce Srimati, you just omit that. You just say Lalkum Tiri.
My Lord. If I may continue.
Yes.
Went to the house of the decree holder 2 times to pay the money as per Lok Adalat award in the month of June 2010. But the decree holders, Dartuama, refused to receive the money on both occasions by saying that his family would discuss it and later inform them. While the judgment debtor were waiting for the reply from the decree holder filed a civil suit for eviction against the judgment debtor, which was registered as civil suit number 84 of 2011. So, my Lord, we have stated in our written objection that attempts were made to comply with the order of the Lok Adalat, my Lord.
They file a civil suit for eviction.
Yes, my Lord.
Where is that civil suit?
This is in annexure number 1 in the instant.
So this civil suit was filed.
Yes, this is for eviction. However, it was dismissed. Yes, it was dismissed on the ground that the learned trial court was of the considered opinion that the instant respondent herein had suppressed material facts. This is at...
You also have suppressed so many things.
My Lord. Then,
You could have mentioned all these things in your application for condonation of delay.
yes, my Lord.
Simply writing 3-4 paragraphs
My Lord.
here and there will not help you.
My Lord.
Now, your case is that after that Lok Adalat
Yes.
order, you approached them to pay the money
Yes, my
on 2
Lord.
occasions.
On 2 occasions.
They refused.
Yes.
They said they will think about it.
Yes.
Instead, they filed a civil suit.
Yes.
Now, where is that civil suit? And what is the claim?
Civil suit is for eviction, my Lord. The instant respondent hearing...
Civil suit is for eviction.
Yes. This is,
Why don't they just file eviction suit?
my Lord.
Civil suit for recovery of money, civil suit for damages.
My Lord.
Everything is civil suit. It's a common nomenclature of what? Mr. Thangram Sang?
Murmu.
Huh?
I don't know about this suit, my lord.
Civil suit for eviction.
Sorry.
You'll file civil suit in the MSCT also, I think, tomorrow.
No, my
Huh?
lord. I have no knowledge about this civil suit.
You have given a copy?
No, my lord.
Why? You should have given him copy.
My lord.
You should enlighten him also.
Yes, we have
He's only, he know only that creamy layer. You don't know what lies beneath that. You start digging, then so many things are coming out now.
My lord.
Execution case, civil suit. It started from Lok Adalat.
Yes.
From Lok Adalat, then you have civil suit. No, then you have eviction. Then you have revision.
Civil, yes.
Then one more revision here, accompanied by condonation of delay.
My lord.
So all these things you could have mentioned in your application for condonation of delay in order to convince the court that there is a case for delay, that there's a case for condoning the delay,
My lord.
isn't it?
My lord.
So you should take due care. You can just write 2 pages like that and say court will condone. If the delay is not condoned, then what is the next step available to you? You have to go to Delhi,
Yes.
isn't it?
My lord.
Or file a review, I don't know. That's why you should be careful. Now, what happened here, the civil suit?
It was dismissed and by this order dated 26/11/2013. And being aggrieved, the instant respondent herein had filed an RFA 5 of 2014.
RFA?
Yes, before the district judge. And the district judge had...
Just a minute. Where's the civil suit order?
Civil suit order is at annexure number 1.
Okay. What is the operative portion?
From
Operative portion.
7, 8, 9, 10, 11, 12, 13, 14.
And what
Page
is-
number 15, my lord.
Paragraph number 1. This is a suit for eviction.
Yes, of the defendant from the landed property of the plaintiff covered by LSC number so and so, and for any other consequential relief. Plaintiff himself pursued the case through his counsel, where the defendant's affair is tended by his power of attorney holder, aided by a legal aid counsel appointed by Member Secretary, Mizoram State Legal Services Authority.
Okay, now you come to the order. Operative.
Yes, my lord.
Present suit hereby dismissed.
Yes. On contest without cause. There is no order as to cause because the defendant is represented by a legal aid counsel and the same is not prayed for. The interim injunction order against the defendant rendered by my predecessor, Civil Judge 1 Aizol, via memo number so and so, dated so and so, and the same maintained via memo number so and so, dated so and so, hereby stands vacated.
What was the interim order which is vacated?
My lord, the interim order that has been passed has not been reflected in this instant order, my lord.
That's why I'm asking you.
Yes.
If you don't know, say you don't know. That's all.
My lord.
Then next.
And in the next page, this RFA order, by this order, the first appellate court was pleased to set aside and quash the set dismissal order and
I see.
ordered for trial de novo. And in the next page, my lord,
Uh,
by order dated 03/12/2019, the case was withdrawn by the instant respondent herein with liberty. And so thereafter, my lord, thereafter execution case was filed.
For execution of the Lok Adalat order.
Yes, for execution of the Lok Adalat order. After Lok Adalat order was passed, the instant respondent herein had filed this civil suit number 84 of 2011. It was dismissed, RFA was filed, and again, the same was withdrawn. So thereafter, execution case was filed.
Now question is, did you also contest the civil suit?
Yes, I have contested through legal aid counsel. I was given a
Legal aid counsel
yes.
in the civil suit.
Yes, my lord.
Then in the appeal,
In the
appeal, RFA, RFA, yes.
yes, my lord. Same legal aid counsel.
Okay,
His name is reflected.
okay. Same legal aid counsel.
Yes, his name is reflected.
What is the name of the respondent? The present Lal Chanpuya, is it?
Lieutenant Puya is, my lord, the applicant herein. The respondent is Datwama.
I know. So you are the Lieutenant Puya.
Yes, my lord.
So you are represented by legal aid counsel.
Yes, my lord.
Then in the civil suit,
Yes. In the civil suit also, I was represented through legal aid counsel.
okay. So all the time you are represented by somebody.
Yes.
Then how come you don't know about the execution case? Disposal of execution case?
My lord, in execution case, I was represented by yet another counsel. My lord.
Correct. You are represented. You also are aware about it,
Yes.
isn't it?
Yes, my lord.
It's not that behind your back they engage somebody, you don't know what has happened.
My lord.
You are aware that they have engaged somebody to defend you.
Yes.
So now it's back to square one. You claim ignorance. You were not aware about this disposal,
My lord.
dismissal,
My lord.
or disposal.
Disposal of the execution case. My lord.
Yes, Mr. Thangram Sang, anything to add?
Ram Murmu, my lord. My lord, regarding that civil suit, I have no knowledge as of now, and regarding the RFA as well. So my submission is finished. Nothing.
Okay, please write. Heard Mr. Tilal Zekima, learned counsel for the applicant, and Mr. Thangram Sang, learned counsel.
Ram Murmu, my lord. Ram
I'm
Murmu.
sorry. Mr. Ram Murmu for the respondent. Okay. By filing this application, under Section 5 of the Limitation Act, 1963, the applicant prays for condonation of 427 days delay in filing the connected civil revision petition against the order dated 26/9/2023, passed by the Court of Civil Judge, Aizawl, in execution case number 22 of 2020. Could you get the printout of the judgment? Where is it? There was a book yesterday. I told you take a printout of that. Okay, this one. Referring to the application, Mr. Tilal Zekima, learned counsel, submits that after the order dated 26/9/2023 was passed by the executing court, the applicant inadvertently approached the Court of District and Session Judge, Aizawl, by filing civil revision petition under section 115 of the Civil Procedure Code 1908 (CPC), and the same was registered as civil revision petition number 23 of 2024. Stop. Since there was delay in filing the same, civil miscellaneous application number 562 of 2024 was filed seeking condonation of 246 days delay in filing the civil revision petition. Stop. He submits that although the applicant was represented by a legal aid counsel, he was not informed about the disposal of the execution case. And it was only in the month of December 2023 that he became aware. To stop, the applicant was having financial difficulties, and therefore it was only in the month of January 2024 that he found an advocate who was willing to take up her case. Stop. Thereafter, copies of the related documents were obtained in the month of February 2024. But the State Council informed the applicant that he will not be able to pursue the case. After applicant, you write, inform the applicant on 21/3/2024 that he will not be able to pursue his case in the district court. To stop, the applicant being a daily wage worker and working in a construction site as helper could not pursue his case. Stop. Subsequently, in the month of May 2024, the applicant met another advocate who was willing to take up the case on pro bono basis. same was pending for about 7 months, along with an application for toleration of delay in filing the same civil division petition. From the applicant withdrew the same. Upon realizing that the civil division petition was not like before the state court, COURT, under section 115. The other council submits that although the applicant has sought for toleration of delay by also relying upon section 14 isn't it?
My lord.
14 of the Limitation Act. The applicant has failed to show any bona fide in approaching the wrong forum. But in other words, he submits that the applicant has not been diligent in pursuing this case, and for which reason the delay should not be prolonged. The other council submits that there is an unexplained delay for about 40 days. For the month of March, yes. From 21/3/2024 to 30/4/2024. And thereafter, from 4/5/2024 to 4/6/2024. So the other council submits that the explanations so made are very sketchy and in fact they are only an afterthought. Stop the other council submits that the explanation tendered cannot be considered as an explanation per se, but only an excuse to seek combination of application. Stop. He submits that an excuse, unlike an explanation, would not be acceptable for prolonging the delay because the same lacks bona fide. He thus supposes that under the facts and circumstances, there has been inordinate delay in filing the civil division petition. to my friends to hand over the sum of money, 45, to the respondent in the month of June
10, my lord.
2010. But the laptop had refused to say, saying that they will have a discussion within the family. So, thereafter, there was no news about the discussion in the family, and the respondent instead had initiated civil suit number 84 of 2011 against the applicant. The civil suit, however, was dismissed by judgment dated 23
My lord, 26/11/2013, my lord.
was dismissed by judgment dated 26/11/2013. So, the respondent had filed RFA before the first appellate court. That is explaining the delay. By giving necessary particulars such as the 11 dates, comma, the date or month. The 11 date. So in other words, the explanations made in the application appears to be sketchy, as rightly pointed out by the current council for this one. So, however, one aspect of the matter which has drawn the attention of the school is that, according to the applicant, the executive court had misdirected itself in passing the review order, which was not in terms of the order passed by the Lok Adal. Which paragraph do you go about?
Paragraph number 12, my lord. Paragraph number 12, the first sentence.
The against spoken in the case of Dero Nagaland versus Jacob Ham and others, Supra, had referred to in having noticed some deficiency in the explanation tender for explaining the delay. This scope is of the considered brief that it will be for the ends of justice that the delays for rule and the corrected petition be considered for merits. It's not according to the delay of 4.7 days to pass through. I understand this is
Deeply obliged.
Yes, my lord. Yes. My lord, I haven't received the copy of the revision petition.
My lord, my lord. Yes, yes, my lord. My lord, we have taken, yes, by way of undertaking. Yes. My lord, my lord. Definitely. Yes. Obliged, my lord.
Item 8.
My lord, in this matter, the leading counsel, Mr. Jonathan Lalrinklonga, is indisposed of. Item number 8. Item 8. Yes. Yes, Jonathan Lalrinklonga. I am not leading the case, my lord. Sorry, my lord. It's Friday also, yes. Friday also, my lord. If okay, Monday. Yes, my lord.
There's no objection, madam. Obliged.
Item 2.
My lord, may I seek for only further 2 weeks' time to file reply affidavit, my lord. Reply, yes. 2 weeks' time, my lord.
No, no objection there.
Much obliged.
Item 3.
Judge, I think the additional ages on Lex in court number 3. He was directed to. No, Mr. Samuel. There was a direction for them to file an additional affidavit. In fact, he had informed me he'll be filing it within a week. Well, let it come up towards the end of the week. By then, I think you can file it. Thursday. Next Thursday. Thursday?
Be filing it within a week, my lord. I've received the along with the OM, my lord. Yes, your lordship. Any can be moved.
Nine, 19. I move.
Obliged, my lord.
Item 4.
May it please your lordship, as directed by your lordship, I have filed the additional affidavit on 28/2/2025, wherein I have incorporated the application of the respondent before the trial court, along with the annexures and the affidavit of her sister and herself. The application would starts from page 6 of the affidavit dated 28/2/2025. Earlier, but as allowed by your lordship, I have filed the additional affidavit on 3/2/2025.
Enclosing the succession certificate.
Yes, my lord.
And after that, what was required then?
After that, since I have not enclosed the application filed by the respondent
For?
For obtaining succession certificate before the trial court, I was instructed to file the additional affidavit.
So you have filed two additional affidavits.
Yes, my lord.
One is a succession, the other one is application for succession.
Application for succession filed behind my back before the trial court.
So why is it listed today?
Today is for admission hearing, my lord.
Yes, my lord. In fact, your lordship, to be honest, I have no objection if it is remanded to the trial court, because it was issued, in fact, it was issued without any notice, although examination in chief was invited, which was duly submitted before the trial court. Yes.
The affidavit dated 3/2/25, my lord.
Mr. Zoram Chana, just tell me the brief facts of the case.
The brief facts of the case is that the petitioners are the second wife and minor children of Larem Sanga. Larem Sanga was initially married to the mother of the respondent, and the respondent is the daughter from the first marriage. And after Larem Sanga died, concealing the fact that he had a second wife and other minor children, she approached the trial court and informed the trial court that she is the one to inherit the money left behind by the said Larem Sanga. And the trial court, without issuing any notice, and since she has played fraud by concealing material facts, she had obtained these succession certificates. This is RFA, my lord. The appellant is Vilal Dinpui and her three minor children, second wife, and minor children from the three, my lord. petitioner number 2 is 11 years, and petitioner number 3 and 4 are twins, and they are 7 years respectively. Yes.
We'll send it back.
Yes, my lord, I have one small request.
Yes.
Since it pertains to money left behind by the deceased, let the sum of money which he had wrongfully obtained from the bank by using the succession certificates may be deposited to the trial court. 35,61,511 and 53 paise. Everything is withdrawn.
My lord, I will raise an objection to that, because although at this stage I am not sure whether it is these amounts are withdrawn already, but he has an option before the learned trial court as well to invoke the relevant provisions under CPC also, my lord.
Yes, my lord. 35,61,511.53.
Okay. This is from the account of
The account of Larem Sanga, 4 accounts.
Nalrem Sanga, the deceased.
The deceased.
4 accounts.
Yes, my lord.
Which bank?
Bank, Mizoram Cooperative Bank, Mizoram Cooperative Apex Bank, amounting to rupees 25. Court. 6 lakhs. Court. 6 lakhs 7,651.18, and 6 lakhs 7,651, 607,651.18. Mizoram Rural Bank, Aizawl branch. Bank, Aizawl branch. Zarkot. Aizawl branch, Zarkot, my lord.
So that's all.
And Yes Bank Limited, Aizawl. 1,95,264. 1,95,264.57 and 64.57, and from Mizoram Cooperative Apex Bank, Centenary Mission Bank, Aizawl, 1,62,000. Mizoram Cooperative Apex Bank, Centenary Mission Bank, Aizawl. Yes, my lord. 162,000.
So we'll just come back in 5 minutes.
Yes, my lord.
And we'll pass the orders. I think we'll not mention any details. We'll just say that some bank accounts are there, some money is there which has been given to the other side, and you may file an appropriate application for depositing the same before the trial court. Court will consider it accordingly. Heard, please write down. Heard Mr. Zoram Chana, learned counsel for the appellant, and Mr. Bilal Ramenga, appellants, yes, appellants, and Mr. Bilal Ramenga, learned counsel for the sole respondent.
Yes, ma'am.
Stop. This is an appeal filed under Order 41, Rule 1 CPC, read with Section 17, bracket 2 of the Mizoram Civil Codes Act, 2005, isn't it? Is it 2005 Civil Codes Act?
Yes, my lord, 2005.
2005. Challenging the validity and legality of the impugn order dated 14/2/2024, along with the impugned succession certificate number 48 of 2024, bracket small a, bracket small b, bracket small c, and bracket small d, passed by the Court of Civil Judge, Senior Division 1, High Zone. In succession certificate, case number 48 of 2024. Respondent is the first wife. Respondent?
Respondent is the daughter from the first marriage.
The elder daughter, my lord.
Okay. Next para, it is the case of the appellants that the appellant number 1 is the legitimate wife of deceased Sri Lal Remsanga, who expired on 16/12/2023. And the appellant numbers 2, 3, and 4 are the children. First off, the sole respondent is the daughter of the deceased person from his first marriage. First off, according to the appellants, the deceased person had left behind. Is it only about the bank account money?
Yes.
Nothing to do with the property?
Property, there is another case pending before the
Okay,
trial court.
in this case only regarding money.
Yes, my lord.
It is the case of the appellants that the deceased person had left behind certain amount of money in 5 different bank accounts, and for which the sole respondent, without informing them and without their knowledge, had secured the succession certificate First off, the total amount of money deposited in the 5 bank accounts comes to rupees 35,61,
My lord, since I've missed out one.
okay,
35,70509.
just repeat.
35,70509.06.
Okay. Our total amount deposited in the 5 bank accounts is rupees 35,70,509.06. Can I record that you have no objection?
Yes, just with regard to remanding back the matter, my lord.
Okay. It therefore appears that without hearing the appellants or any person interested, the learned court below had apparently granted the succession certificate to the sole respondent. And in the considered view of this court, the same should be reconsidered by the learned trial court by giving due opportunity to all the parties interested. Mr. Bila Ramenga as well as Mr. Zoram Chana, learned counsel, do not have any objection if the matter is remanded for fresh consideration. First off, Mr. Zoram Chana further submits that the amount which has been given to the respondent. No, the right like this. Mr. Sriram Sara submits that pursuant to the grant of succession certificate to the respondent, the amount lying in the 5 bank accounts has been given to the respondent, and therefore pending reconsideration of the succession certificate, the said amount should be deposited before the court. Next para. Considering the submissions made, the matter is remanded back to the learned trial court for fresh consideration by giving due opportunity to the parties interested. Since the parties are represented before this court, they are directed to appear before the learned trial court on suggested date. Today is 11th.
23rd, my lord.
23rd?
Yes, my lord.
On 23rd of June 2025. Whereafter the learned trial court shall proceed with the matter in accordance with law and make an endeavor to dispose of the case as expeditiously as possible. Full stop. The appellants if so advised may file appropriate application seeking the deposit of the amount of money kept in the 5 bank accounts by late Nalram Sang.
My lord, I think it has been withdrawn by her at this stage, all this money.
In that regard, my lord, I have no instruction at this stage.
What did I say? Please read again. So even if it's withdrawn,
Yes, my lord.
so it's one and the same thing.
No, it will no longer be in the account of Lalrem Sangha, my lord, at this stage. It will be withdrawn.
Okay, please read again once more. The seeking, the rest you cut. Seeking appropriate security deposit by the sole respondent herein, pending final conclusion, final disposal of the succession certificate. Stop. In the event such an application is filed, the learned trial court shall consider the same and pass appropriate orders as it deems fit and proper. Next para, with the above observation and direction, the appeal stands disposed of. LCR is here? No.
No, I don't think so, my lord. My lord, trial court may additionally be specified as senior civil judge 1.
Yes.
Civil
Okay.
judge senior division 1.
After trial court, you write that is senior civil judge?
Civil judge senior
No,
division 1.
civil judge senior division,
One.
Roman 1.
Yes.
Eyes on.
Much obliged, my lord.
Yes.
Obliged, my lord.
Item 5.
Yes, my lord.
Yes.
Lordship, I am appearing on behalf of respondents 7 and 8, and I will be filing my affidavit in opposition within this week.
Okay. What about the others? 6, 9, and 11?
Lordship, I'm appearing on behalf of respondent 9 to 11.
Yes.
Lordship, I previously submitted that I will not be filing affidavit on behalf of
Okay,
the
yes.
respondent.
Then it's okay. Then 9 and 11, isn't it? Then what about CGC?
CGC have already filed.
Okay. Then you write as paid for by Ms. Caroline Kelung Oipui, learned counsel, learned government advocate, appearing for respondent numbers 7 and 8. A week's time is granted for filing counter affidavit as paid for.
Obliged.
List again after a week.
Lights.
Item 6.
Your Lordship, in this matter, I'm appearing for respondents 9 to 58. So may I seek for further 2 weeks' time to file affidavit in opposition? I have just recently received the affidavit filed by the state, my lord.
9 to 58.
Yes, my lord. Private
What
respondents.
does this matter? So many of them.
This is regarding,
You know-
yes, exclusion of the petitioner's name from in the seniority list.
What,
Ward
what,
superintendent.
what
Well,
service
the-
is this?
The petitioners are working as ward superintendents in ZMC, and they were appointed by the government, but they have been left out of the seniority list prepared by the government for ward superintendent.
What superintendent? Okay.
So they, yeah, their claim is that they should be included in that
Okay.
seniority list.
Okay. Parties are represented by the respective councils. Mr. B. Lal Ramenga, learned counsel, appearing for respondent numbers 9 to 58, submits that he may be given. How much time?
2 weeks' time, my lord.
2 weeks' time to file counter affidavit. And prayers allowed. It is also noticed that as far as the state respondents are concerned, they have already filed the counter
Yes,
affidavit.
my lord.
List again after 2 weeks. Any rejoinder required?
Yeah, I'll go through it. One point they have raised, Your Worship, in the affidavit is that recently the government has taken a decision to take over ZMC, and they are still deciding how to treat the people working in ZMC,
What are the petitioners?
ward
What?
superintendents,
Only ward superintendents?
Yes.
No other?
no other posts.
Okay.
So, I mean, if any decision
So,
has been taken by the
okay.
government,
Like ward superintendent, whoever works in ZMC,
yes.
they are treated differently?
According to the government, yes, because they say the ZMC is a society. So, although the posts were created by the government, since ZMC is a society, they have their own rules and regulations, bylaws. So they come under a different category, ex-cadre posts.
Okay.
But recently, the government has decided to take over ZMC again.
Okay.
So it's no more a society. So
Then things will change.
things will change.
All right. Your objection, what would be your objection? You are already in the seniority list, isn't it?
Yes.
Somebody else wants to come in.
Yes, Your Lordship.
So they cannot be over you, they'll be after you only.
But they are, the ZMC is an autonomous body, my lord.
Was.
And the recruitment was also for the sole purpose of that ZMC, the service which they have to render under ZMC only, my lord.
See, I don't think you'll have any problem as long as they are up below you.
But regarding seniority, Your Lordship,
That's what. If they come below you, you have no problem. But if they come above you or if they interspace you, then problem will arise.
yes, the
Isn't it?
promotion avenue, my lord, there could be a problem.
Okay.
That is why.
What superintendent, then what next promotion?
Sister. No, sister.
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 In fact, Your Worship, they'll also, the zone of consideration for promotion, I mean, a number of posts in the promotion posts will increase for them also. It's the other way around also. Because the post of sisters in ZMC it'll be open for them also to be promoted to those posts.
The promotional post is nursing superintendent.
Nursing superintendent.
Earlier it was designated as sister.
Sister,
Yes.
nursing superintendent.
Yes, nursing
Any other
superintendent.
post above that? Nursing superintendent, top post.
Yes, it appears, my lord. So if they come under seniority list, the same seniority list, then the promotional chance,
Will increase for you.
no, there will be a problem for us. my
For
lord.
him it's decrease, for you it's increase.
But
Okay.
Your Worship, the latest development is now the government has decided to take over ZMC. There's already a decision made by the government. But how the employees working in ZMC are to be treated, that decision is still pending. Whether they'll be treated as normal government servants or, I don't know, some special
So,
category.
are you hinting that there will be more cases coming up?
No, I'm just hinting that, I mean, if the government makes a decision, I mean, that will cover the case.
No, if a new policy comes into place, then of course there will be some who are happy, some who are not
Yes.
happy.
Yes.
Some who are not happy.
Some may come to
So
the court
they
again
are-
against that
They'll
decision.
ultimately end up here only. Anyway, 2 weeks' time.
Much obliged.
Part 2, item 8.
Yes, Mr. Subedi, what is this matter? Mac appeal. Mac appeal. Is a case of death or injury?
Death.
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 How much is awarded?
The awarded amount is
Both of you may go.
25
I'll
lakhs,
call you if it's required.
53,000.
How much?
25 lakhs, 53,000.
No, please come again.
25 lakhs, 53,000.
25 and 53.
Yes.
Okay.
Yes.
It's case of death.
Yes.
And who is the claimant?
Clement is the mother of the deceased.
And what was he doing?
He was said to be a taxi driver.
Taxi driver.
Taxi driver earning rupees 15,000.
15,000.
Yes.
Is there a notional income?
No,
15,000.
no. The owner of the vehicle said that he used to engage him by paying 15,000 per month. So that has been taken into consideration by the trial court.
15,000 is not notional.
Not the notional
Earlier,
income.
during that schedule, second schedule,
Yes.
15,000 was a notional income.
No, much lesser than that, because in 163A, the income cannot exceed. That was the
No, no,
regulation.
15,000 per annum, not monthly.
Oh, per annum, yes. 40,000.
I don't know whether
actually.
it's correct or not.
40,000.
It's correct, also. Per annum is correct.
Per annum, 15,000.
I see.
The maximum ceiling was 40,000.
Yes, probably that. Lordship, the
How much is the interest awarded
7%
from?
the date of filing. The date of filing is 5/9/2019, and the judgment is 8/12/2022.
8, how much?
8/12/2022.
8/12/2022.
And the interest should be counted from 5/9/2019 at the rate of 7%.
Okay.
Lordship, this case basically on 2-3 grounds appeal has been filed.
What is that?
One ground is that in this case there is no FIR. As has been stated by the claimant, the FIR was not immediately submitted, and once they approached the police officials for submitting the FIR, the OC of the concerned police station denied filing FIR because the police says that it is already late and they cannot file it because in the system it could not take up. So they have approached the SP of Aizawl again, and SP also denied. And that is the reason why FIR could not be filed, according to the claimant.
And you've taken that as a ground?
Yes.
There's no FIR?
No FIR. Only on the basis of one of the witness, or the occupants of the taxi driver, this case has been taken into consideration and judgment has been passed. Because no other witnesses were there, apart from one witness who is said to have boarded the vehicles, the taxi, by saying that he has hired the taxi along with his wife. But the wife was not, the wife did not come before the court to adduce the evidence. Only one of the occupants who is said to have hired the vehicle is before the court as one of the witness of the claimant.
The person who hired the vehicle was not inside the vehicle?
He was he is said to be inside the vehicle along with his wife, who had hired the vehicle.
Two persons boarded the taxi?
Two persons.
They escaped?
Oh yes,
they escaped unhurt?
They survived.
But only the
taxi
driver
died. But not immediately, after some days, few days.
I see.
After a few days.
What was the nature of injury? On the skull? Injury?
I think so. I have.
After some days, you say?
Yes.
He died after some days?
Yes, he was admitted to the hospital and he was declared dead.
After some days?
Yes. I'll.
And how many witnesses? Only one witness?
Only one eyewitness and the claimant.
So there are only two witnesses?
Yes, three. Claimant and the one who boarded the vehicle and the employer who said that he has engaged the deceased by giving 15,000 rupees, 3 people, for the claimant.
Taxi belongs to whom? To the employer?
Yes, the one who has deposed for the court.
Okay.
Evidence. In this case,
employer employed the deceased as the driver of the taxi.
Yes.
By giving him rupees 15,000 per month, as per his deposition.
As per his deposition.
And there were 3 persons who boarded who was in the vehicle. Deceased, then husband and wife.
Yes, collided with one vehicle. There is a collision.
I see. Then any other case connected to this? What is the other vehicle?
The other vehicle is tipper.
Truck?
Tipper.
Anyone injured?
No, nothing happened to the other side.
And you are the insurer of the tipper or the taxi?
Tipper.
Oh, you are the insurer of the tipper?
Yes. They are claiming negligence of the tipper.
Okay.
Which caused the death. But the only thing is that we are claiming here, amongst other, is that there is no FIR, and because of that, they have not proved their case.
Okay.
And that is one case. And the other thing is regarding the income. Only one piece of paper in which he has written that he had engaged the taxi driver by paying him 15,000 rupees.
But he deposed, isn't it?
He deposed. But he said that he has nothing on record to show that apart from that piece of paper, no other records to show that he had actually engaged the taxi driver. That is there in the evidence. The trial court had framed 3 issues in this case. One is whether the present claim application is maintainable in its present form and style. The other one is whether there was fault on the part of the driver or owner of the accident vehicle. Then the third one is that whether the claimant is entitled to compensation, and if so, what extent and who is liable to pay. So all were decided in favor of the claimant.
Claim is filed under which section?
166.
166.
Yes.
Fault basis.
Yes. On that basis, the trial court has come up to the finding that according to the evidence of the person who had boarded the vehicle, according to him, he has come to the conclusion that the driver of the vehicle, tipper, was in negligence and therefore awarded the amount.
What happened to the taxi? Badly damaged?
Nothing on record. That question was also put up to this witness before the court, and he said I do not have any photographs to show that there is a damage caused to the taxi. Also, no photographs before the court.
No photograph?
No photographs before the court. That question was also put up before the one sole eyewitness who is said to have deposed. That question was put up before him.
What is the nature of the injury? Any medical certificate enclosed, exhibited?
One discharge summary was exhibited in the claim petition, discharge card. Yes. Yes, they have exhibited one document.
Perforation with ideal mesenteric tear. What does it mean?
No idea.
It's a head injury or?
Appendectomy do GA 120. Procedural performance.
No, I think you read the evidence.
Yes.
On the judgment itself, I think it's there.
Yes. Evidences. The claimant examined 3 witnesses during the course of trial. CW number 1, Lalsang Zwali, aged about 55 years, stated that she is the claimant in the instant case, MSCT 47 of 19, and mother of deceased Lalchandama and legal guardian of Sanghming Thanga. That on the morning of 28/6/2019, around 8, there was a motor accident at Phunchong village. Upon investigation and an eyewitness account, it was found out that her son, Lalchandama, who was riding a taxi with his 2 passengers, namely Lalrin Omi and Larim Moya, were hit by a tipper bearing registration number MZ01 so-and-so, coming from the opposite direction towards Aizol. Lalchandama, that is the driver, and his 2 passengers were injured due to the said accident and were given first aid at Civil Hospital Aizol, but her son Lalchandama sustained severe injuries. He was referred to LRM Hospital due to no vacant bed in ICU Civil Hospital and succumbed to his injuries at LRM Hospital on 1/7/2019. That her deceased son was a driver of taxi bearing so-and-so, and he was employed by the owner of the taxi, namely R. Lal Trazwala, Zongnuam, Aizol, Mizoram, and he used to earn rupees 15,000 per month. That she lived with her deceased son Lalchandama along with his disabled son Sangming Thanga, and also Jennifer P.C. Zaudinthari, who is the daughter of her deceased son's sister at Chanmari West, Aizol, Mizoram, till his death, and she along with Sangming Thanga and Jennifer P.C. Zaudinthari do not have any alternative income, and they totally depend on the income of her deceased son. That the, yes, he is said to be a disabled person, and yes. No, son. The disability certificate is also there in the claim petition. And that the deceased, namely being an employee of R. Trazwala, used to submit whatever money he received from driving the said taxi to R. Trazwala, and that R. Trazwala used to pay him monthly salary regularly amounting to rupees 15,000 per month, and that the income which he received is their only income, and that they totally depend on him and his monthly salary. That since her deceased son was seriously injured and he needed attendance at all times, an FIR regarding the accident of her deceased son was not submitted to the concerned police station during the time of the accident of her deceased son was prepared. The officer in charge of Vivacon police station denied to entertain the said FIR due to reason that all reports in their system were computerized and that all report will be deemed as false because of it. Subsequently, an attempt to submit FIR regarding the accident of her deceased son was made to the Superintendent of Police Aizol, but the FIR was once more denied. That she prayed this honorable tribunal to grant the maximum compensation for the loss of her son, who is the sole bread earner and the sole provider of their family. She exhibited the following documents. These are the exhibits. And my lord, I'm reading from the paragraph. In her cross-examination, she admitted the suggestions that FIR was not submitted immediately in this case, and he has not visited the place of occurrence accident on 28/6/2019, and that she came to know regarding her son's accident on 28/6/2019 from the passengers of the taxi and other witnesses, and that 28/6/2019. And he died on 1/7/2019. And other witnesses, and that Lalchandama, her late son, was the only bread earner of their family, and they solely relied to his income to make our living, and that after the said accident, Lalchandama was taken to civil hospital on 26/6/2019. Probably this is the typing mistake. Where he was operated immediately. She also stated that on the same night, her son Lalchandama was referred to LRM Hospital and was kept in ICU. Thereafter, on 1/7/2019, he succumbed to his injuries in the said hospital. She also admitted the suggestion that there is nothing in writing between R. Lal Trazwala and them regarding the accident which occurred on 28/6/2019, which could show that accident occurred on that day. She admitted the suggestions that Samingthanga, who is the disabled son of Lal Chandama late, has attained majority as on today, and that the vehicle number so-and-so taxi was registered in the name of Sang Thang Liana, and same was not transferred in the name of Sri R. Lal Chazwala till date, and that she was informed that one tank lorry was parked in the roadside. The driver of MZ01 N6026 tried to overtake the said tank lorry, which caused the accident. As far as she knew, the cause of accident is due to the negligence of the driver of tipper MZ01 so and so. However, she can say this as she came to know from the other witnesses and purely hearsay. Her deceased son used to submit his salary of 15,000 to her by the end of each month. However, she did not return any money to him from his salary submitted to her. She actually spent income of her son to meet the daily needs of their family. She married to Sri Sangmuoka, 84 years, and they had two issues, namely Arzonun Sangi and Lalchandama. Her daughter is living separately in different households, and her husband, due to his old age, is unable to earn any income. Exhibit C28 and 29 was not received by the OC, Vivacon Police Station Aizawl, and the Superintendent of Police Aizawl, respectively. She admitted the suggestions that there is no photograph of the damaged vehicle taxi to show that the accident had occurred on 28/6/2019, and that there is no mentioning date in the Shriyatpuina letter, that is Exhibit C31, signed by Srimati Lalrin Omi and Lalrim Moya, and that she had not produced the original exhibits. However, she can produce the same for comparison before this court as and when called for, and that there is no FIR registered in respect of the accident occurred on 28/6 between the taxi and tipper at Punchong, Aizawl, Mizoram. In her re-examination, she stated that with regards to submission of the FIR before the DC and the SP Aizawl, she further clarified that though they have submitted the FIR to the concerned OC and along with SP Aizawl, however, they denied to acknowledge the same as it was submitted belatedly. The evidence of CW number 2 La Remoya. It should be in the claim petition. In the claim petition.
Also, there was an CMA 34 of 2019, wherein we have annexed those exhibit C28, 29 and all.
The accident happened in 28/6. The fire was something, fire was 6 times. Almost after 3 months. 3 hours. Why is it not submitted?
CMA was submitted on 6th November 2019.
When was the claim filed?
Claim was filed on 5/9/2019.
5/9.
After 2 months, the CMA was filed.
FIR was filed on 6/9.
Uh,
Claim was filed without FIR.
yes, correct.
5/9, FIR was filed. I mean, the claim was filed.
Yes,
And on 6/9, application before the OC and before the SP.
probably yes. Yes. The other one is the occupant of the taxi who has hired the vehicle. CW number 2, Lal Remoya. Yes, 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 claimant. 2 is the one who is said to have hired the vehicle, taxi. CW number 2, Lal Remoya, aged about 45 years, stated that he is the claimant witness number 2 in the instant MSCT case number 47 of 2019 and one of the passenger in accident vehicle so-and-so driven by the deceased Lal Chandama. That on 28/6/2019, he hired a taxi driven by the deceased Lal Chandama from Edenthar to Sairang, and he was accompanied by his wife Larinomi Late, who is also one of the passengers of the said taxi. That the driver of the taxi, Lal Chandama, was careful enough to drive the vehicle under speed limit, but unfortunately, while they reached the curve road at Phungchong area, one tipper number so-and-so hit the vehicle which they boarded. The driver of the taxi, Lal Chandama, and the passengers, he and his wife, were all injured due to the said accident, and they were evacuated to civil hospital where they received first aid, and the driver of the taxi, namely Lal Chandama, was transferred to LRM hospital due to the serious nature of his injury and also due to non-vacant bed in the ICU of civil hospital Aizawl. And unfortunately, they were informed that he succumbed to his injuries at LRM hospital on 1/7/2019. That he and his wife Lalrinomi were boarded the taxi number so-and-so during the accident took place. The taxi driver Lal Chandama drove the vehicle carefully and slowly in the extreme corner of the curved road, which is beyond the white line marking at the side of the road. The place of accident is the curved road, and the tank lorry was parked at the roadside, which was overtaken by the tipper MZ016026. As an eyewitness in the said accident, the accident occurred due to the fault of the driver of the tipper MZ01 so-and-so, who drove the tipper very fast in a rash and negligent manner, leading to the said accident. That the cause of the accident was due to the fault of the driver of the tipper, who drove the tipper very fast in a rash and negligent manner, leading to the said accident. He identified Exhibit 32, C32, his signature. In his cross-examination, he admitted the suggestions that the accident took place at Phungchong and that the accident happened on 28 June 2019 at Phungchong, and that there were 2 occupants in the vehicle, but he cannot say the registration number of the accident vehicle. The 2 occupants were Lal Remoya and Larinomi. He also admitted the suggestion that he did not know the registration number of the said 2 vehicles, and that he can say Lal Chandama was careful enough because Lal Chandama had crossed the line drawn on the road, and that though he has said in his examination in chief the vehicle was driven in a rash and negligent manner, he has no clear knowledge of the exact speed of the tipper. He also stated that though in paragraph 2 of his examination chief he has said he had turned taxi number MZ0588, no one witnessed that did he really hire the said taxi or not. He admitted the suggestion put to him that he has no document to prove to show that the said vehicles got accident. The court. In his re-examination by counsel for claimant, he stated that in his cross-examination on point number 6, it is recorded that Lal Chandama crossed the line on the road. He would like to clarify that by saying line drawn on the road, he want to say the line drawn, white line marking on the side of the road. On his cross-examination point number 8, it is recorded that though in para 2 of his examination in chief, he has said he had hired taxi MZ01H0588, no one witnessed that he did really hire the said taxi or not. However, her wife, Larinomi, boarded the said taxi with him. The other witness is the owner of the vehicle who had engaged the taxi driver, CW claimant witness number 3, Lal Traswala. Yes.
Claimants, Your Lordship, yes.
Any other respondents?
No other respondents.
Yeah, all of them by way of the newspaper publication, the service has been completed. They did not appear. Yes,
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 yes.
there are as many as
Then they are not
4
represented.
other respondents, including the claimants.
Yes, Lordship.
This is tipper. 2 is tipper. 3 is driver of the tipper. And 4 is the first owner of taxi. 5 is the other owner of the taxi, which he had purchased from the respondent number 4. Purchased from 4.
Yes. Yes, Lordship.
Yes, yes, correct.
You are reading
Now we are in page number 26, paragraph number 10. We have completed witness number 2.
one was the
Claimant, and the second one
claimant, is the second one is the occupant.
was occupant.
Yes.
Paragraph number
And who
10.
is number 3?
Number
Employer.
3 is the employer, the owner, who had purchased the vehicle. CW number 3,
Yes.
Lal Traswala, stated that he is the employer of the Lal Chandama, who died on 1/7/2019 out of motor accident. That he is the owner of the taxi so and so, and he bought the said vehicle from Ming Tan Liana on date 5/3/2017. That he employed Lal Chandama as a driver of his vehicle taxi, and he used to give rupees 15,000 monthly for his salary. That he employed Lal Chandama as a driver of his taxi from January 2019, and he employed him till his death on 1/7/2019. He identified Exhibit C33 and Exhibit C34, his signatures. In his cross-examination, he admitted the suggestions that he is R. Lal Traswala, the owner of the taxi MZ01H0588. He had purchased the said vehicle from Ming Tan Liana on March 2017 with a sum of 2 lakhs, and he had paid all the amount to Pu P Ming Tan Liana. He admitted the suggestion that on 28/6/2019 and at 8 p.m. the said vehicle bearing registration number so and so met with an accident at Puncham, which was collided by another vehicle which he did not know the detailed registration number and other document of the other unknown vehicle. He admitted the suggestion that there is no police report to show that there was a road traffic accident bearing number MZ01H0588 on 28/6/2019. They had tried their best to produce a police report, but the police authority fails to prepare a police report, and that on 28/6/2019, Lal Chandama met with an accident, and that the deceased Lal Chandama was employed by him since 2019 till his death, and he did not have or maintain any document records to show that the deceased was employed by him, namely R. Lal Traswala, and that he did not maintain any pay receipt to show that the deceased Lal Chandama used to earn rupees 15,000 per month for driving his said vehicle, and that his vehicle used to earn rupees 40 to 45,000 per month usually, and that the deceased was employed by him only 6 months, and that he did not depose false before the court. In his re-examination, he stated that in his cross-examination at point number 3, he would like to clarify that the reason why the police did not issue them a police report was that when they approached the police personnel, they simply told them that all the system in their computer was computerized and that the report will be deemed as false of it. These are the 3 evidence, but
So have you engaged some investigator?
In this case, no report. There is no report,
No
investigation report.
That means you accept it.
No, usually when there is no police report, there is no possibility of doing investigation. Because what usually the investigator do is, they will find out the police report, and based on the police report, they will do the investigation.
Okay, but there's no police report, but at
Yes.
least you must be having some source to find out whether they actually tried to file the FIR or not. And in the locality also, it happened in the middle of the jungle.
No, in between the highway, the road.
Yeah, so there must be somebody there who have actually witnessed the accident. And so far as the claimant is concerned, one of the equipment has been examined. The owner of the taxi has been examined regarding income, and the claimant is the mother. They all say that there was an accident on this day. Is it mandatory in the part of that there has to be a police, there has to be an FIR in order to give compensation? Is there any such law?
There is one citation, probably may or may not help in this case, but I think it can guide us in some sense.
Yes. What is that? Yes.
In this case, a writ petition was filed by one company, ICICI Lombard General Insurance Company. Paragraph 3. I'd like to start from
Yes.
there. By filing this petition under Article 226 of the Constitution of India, petitioner seeks a direction to Respondent number 2, Director General of Police, Assam, to reinvestigate all the road accident cases pending in the Motor Accident Claims Tribunal in the state of Assam, which are being proceeded on the basis of General Diary, GD entry. Further, prayer made is for a direction to the Motor Accidents Claims Tribunal not to entertain any claim for compensation on the basis of General Diary, GD entry, and to seek appropriate police investigation into the road accidents on the basis of which claims have been made. Petitioner is the ICICI Lombard General Insurance Company Limited, having its registered office at Mumbai and so. Basic grievance of the petitioner is that in the state of Assam, information relating to motor accidents are entered by the police in the respective police stations in the GD, whereafter the GD entry is forwarded to the concerned Motor Accident Claims Tribunal on the basis of which the claims are registered. It is contended that forwarding of GD entry to the tribunal is not in conformity with the law. Besides, there is no corresponding police investigation into such cases of motor accidents. Therefore, it is contended that unless there is proper investigation leading to registration of a FIR, no cognizance should be taken by the tribunals. Only a FIR should be forwarded to the police stations to the tribunals and not the GD entries. Therefore, all the claim cases which are now pending before the respective tribunals on the basis of GD entries should be investigated again by the police, and only after registration of FIR, those claim petitions may be taken up. It is contended that such prayer is not only legitimate in view of the legal positioning governing the field, but would also go a long way in weeding out fake claims. Petitioner is a trustee in charge of public money, and when the tribunal award compensation to victims of motor accidents, compensation is paid out of public money. Therefore, it is important that necessary precautions should be taken and there should be proper investigation before such claims are entertained. Notice in this case was issued on 30/8/2017. Though no affidavit has been filed by the state, a short written statement has been filed by the learned government advocate on behalf of the state. Response of the state is that in all the claim proceedings, the insurance company is invariably one of the parties, insurance companies, prove the falsity of the claim if the claim is not genuine. Insurance companies have ample opportunities under law to establish falsity of a claim if it is indeed a false claim. If an insurance company has any grievance regarding non-performance of duty enjoined upon the police officer to register a FIR to conduct investigation, the same can be brought to the notice of the tribunal. Under Section 168 and 169 of the Motor Vehicles Act 1988, tribunal has to hold inquiry into the claim made by the claimant following summary procedure. The procedure has to be inquisitional, and it is the duty of the tribunal to ascertain the truth of the claim in order to render justice. Tribunal is not powerless to find out a false claim and thereafter to pass necessary orders. Detailed submissions have been made by so-and-so and so-and-so, learned counsel for the parties, which have been duly considered. Subsection 6 was inserted in Section 158 of the Act by way of amendment in the year 1994. As per subsection 6, as soon as any information regarding any accident involving death or bodily injury to any person is recorded or report under this section is completed by a police officer, the officer in charge of the police station shall forward a copy of the same within 30 days from the date of first recording of information, or, as the case may be, on completion of such report to the tribunal having jurisdiction, and a copy thereof to the concerned insurer, and where a copy is made available to the owner, he shall also, within 30 days of receipt of such report, forward the same to such claims tribunal and insurer. Section 158, bracket 6 of the Act reads as under. As soon as any information regarding any accident involving death or bodily injury to any person is recorded or report under this section is completed by a police officer, the officer in charge of the police station shall forward a copy of the same within 30 days from the date of recording or recording of information, or, as the case may be, on completion of such reports to the claims tribunal having jurisdiction, and a copy thereof to the concerned insurer, and where a copy is made available to the owner, he shall also, within 30 days of receipt of such report, forward the same to such claims tribunal and insurer. Thus, this section makes it mandatory for an officer in charge of the concerned police station to forward to the jurisdictional tribunal within 30 days of receipt of information regarding any accident involving death of or bodily injury to any person, the information so recorded or the report after completion of the same. Section 165 of the Act provides for constitution of motor accidents claims tribunals, already referred to as tribunal, for the purpose of adjudicating upon claims for compensation in respect of accidents involving the death of or bodily injury to persons arising out of the use of motor vehicles or damages to any property of a third party so arising, or both. Section 166 of the Act deals with application for compensation. Subsection 4 was inserted in Section 166 by amendment in the year 1994. It says that the tribunal shall treat any report of accident forwarded to it under subsection 6 of Section 158 as an application for compensation under this Act. Section 166(4) of the Act provides as under. The claims tribunal shall treat any report of accidents forwarded to it under subsection 6 of Section 156 as an application for compensation under this Act. Rule 150 of the Central Motor Vehicle Rules 1989 deals with furnishing of copies of reports to claims tribunal. It says that the police report referred to in subsection 6 of Section 158 shall be in Form 54. A registering authority or a police officer who is required to furnish the required information to the person eligible to claim compensation under Section 160 shall furnish the information in Form 54 within 7 days from the date of receipt of the request and on payment of a fee of ₹10. This rule was framed in 1989, whereas the amendments were made in the Act in 1994. It appears that the legislative intent leading to insertion of subsection 6 in Section 158 and subsection 4 in Section 166 of the Act is not reflected in Rule 150 of the Central Motor Vehicle Rules 1989. However, it is right that provisions of the rule has to be read or interpreted in a manner so as to give effect to the provisions of the Act and not in derogation of the same, reverting back to Section 1586 and 1664 of the Act. What is discernible is that an officer in charge of the police station is mandated to forward the information regarding motor accident to the concerned tribunal within 30 days of recording of such information or on completion of such report. Such report shall be treated as an application for compensation under Section 166. This virtually nullifies the requirement of making a request for furnishing of information to a person eligible to claim compensation under Section 166 of the Act and for payment of fee as per Rule 150 of the Central Motor Vehicle Rules 1989, rendering such provision redundant. In General Insurance Council versus State of Andhra Pradesh, the General Insurance Council had approached the Supreme Court seeking a direction to the state governments and to the union territories to ensure that the mandate of Section 1586 of the Act was complied with without exception. Supreme Court directed that all the state governments and union territories should instruct all police officers concerned about the need to comply with the requirement of Section 1586 of the Act, keeping in view the requirement indicated in Rule 150 and in Form number 54. Periodical checking should be done by the Inspector General of Police to ensure that the requirements were complied with. In case there was non-compliance, appropriate action should be taken against the erring officials. Relevant portion of the decision of the Supreme Court in General Insurance Council (SUPRA) is extracted hereunder. The language used in subsection 6 of Section 158 mandates the police officer to forward a copy of the report to the claims tribunal having jurisdiction and to the concerned insurance company as soon as any information regarding any accident involving death or bodily injury is recorded or a report under Section 158 is completed by the police officer. Use of the expression as soon as implies that there has to be promptitude in action. To do a thing as soon as possible means to do it within a reasonable time, with an understanding to do it within the shortest possible time. As and when and as soon as are almost synonymous. Whenever these expressions are used in respect of time and place, they denote contemporaneous notion. As soon as and forthwith, both are to be normally understood as allowing reasonable time, but later to be peremptory than the former. But urgency is the hallmark of both expression. Expression as soon as may be stressed to mean as soon as practicable. It has to be forwarded with promptitude. Since there is a mandatory requirement to act in a manner provided in Section 1586, there is no justifiable reason as to why the requirement is not being followed. It is therefore directed that all the state government and the union territories shall instruct, if not already done, all police officers concerned about the need to comply with the requirement of Section 1586, keeping in view the requirement indicated in Rule 150 and in Form 54. Periodical checking shall be done by the Inspector General of Police concerned to ensure that the requirements are being complied with. In case there is non-compliance, appropriate action shall be taken against the erring officials. The Department of Road Transport and Highways shall make periodical verification to ensure that action is being taken, and in case any deviation, immediately bring the same to the notice of the concerned state governments, union territory, so that necessary action can be taken against the official concerned. The above issue again came up before the Supreme Court in J. Prakash versus National Insurance Company. Supreme Court referred to the provision contained in Section 1586 and 1664 of the Act, as well as the earlier decision in General Insurance Council (SUPRA), and lamented that neither the police nor the tribunals had made any effort to implement these mandatory provisions of the Act. It was observed that if these provisions are faithfully and effectively implemented, it would be possible for the victims of accident and or their families to get compensation in a span of few months. Therefore, it was held that there was an urgent need for the police authorities and the tribunals to follow the mandate of this provision provisions. Supreme Court in that case issued a number of directions to the police authorities as well as to the tribunals. One of the directions issued by the police authorities was that Accident Information Report AIR in form number 54 of the Central Motor Vehicle Rules 1989 should be submitted by the police to the jurisdictional tribunal within 30 days of the registration of FIR. While submitting the information in Form 54, police should also collect and furnish important particulars in the Accident Information Report, such as age of the victims at the time of accident, income of the victim, and the names and ages of the dependent family members. The Accident Information Report, AIR, should be accompanied by attested copy of the FIR. Registrar Generals of the High Court were directed to instruct all claims tribunal within the jurisdiction of each High Court to register the reports of accident received under Section 1586 of the Act as applications for compensation under Section 1664 of the Act and to proceed with them without waiting for filing of claim applications by the injured or by the family of the deceased. It was further directed that the tribunals should inquire and satisfy themselves that the Accident Information Report AIR relates to a real accident and to ensure that there is no collusion and fabrication of accident. In this connection, Supreme Court referred to what it called the police officer advocate Dr. Nexus. In Lalita Kumari and Government of Uttar Pradesh, Supreme Court has made it abundantly clear that the registration of a FIR under Section 154 of the Code of Criminal Procedure 1973 is mandatory if the information discloses commission of a cognizable offense. In such a case, no preliminary inquiry is permissible and this provision must be strictly complied with. Before we advert to the grievance of the petitioner, provisions of Section 168 and 169 of the Act may also be referred to. While Section 168 deals with award of the claims tribunal, Section 169 deals with procedure and powers of claims tribunal. A careful and conjoined reading of Section 168 and 169 of the Act would reveal that while adjudicating a claim for compensation, tribunal is empowered to hold an inquiry into the claim made, which perforce includes the veracity of the claim and the truthfulness of the accident. While conducting such an inquiry, a tribunal has all the powers of a civil court for recording evidence. According to the petitioner, in several cases, police officials had made GD entries of information relating to motor accident and forwarded those to the concerned tribunals, which were thereafter treated as claim petition under Section 1664 of the Act. Highlighting such anomalies, petitioner had approached this court earlier by filing WPC so-and-so, which was disposed of by single bench of this court, White Order so-and-so, directing the respondents to follow the directions, guidelines issued by the Supreme Court in Jai Prakash Supra and to complete the investigation on road accident cases. However, notwithstanding such direction, there has been no implementation by the respondent compelling the petitioner to approach the court again. If the decision of the Supreme Court in Jai Prakash Supra is carefully examined, what comes to the fore is that the officer in charge of the concerned police station is required to submit Accident Information Report AIR in form number 54 to the jurisdictional tribunal within 30 days of the registration of FIR. The GD entry is only an entry in the general diary maintained in a police station, recording receipt of information. If the information pertains to cognizable offense, registration of FIR is mandatory. No preliminary inquiry is required to registration of FIR in such cases. It, however, does not mean that after registration of FIR, there is no power of the police to conduct investigation about the genuineness of the road accident. Direction of the Supreme Court is that after registration of the FIR, the Accident Information Report AIR has to be submitted to the jurisdictional tribunal within 30 days. Therefore, and having regard to the discussion made above, Director General of Police DGP Assam is directed to issue general instruction to all the police stations in the state of Assam to register FIR after making GD entry on receipt of information relating to road accidents and thereafter submit Accident Information Report in form number 54 of the Central Motor Vehicles Rules 1989 to the jurisdictional tribunal within 30 days of FIR. Insofar, the claim cases already pending before the tribunals, which have been registered on the basis of GD entries, court is of the view that, having regard to the beneficial nature of the legislation, that is the Act, it would be wholly inequitable to direct remand of those claim petitions to the concerned police stations. As discussed above, under Section 168 and 169 of the Act, the tribunal has got ample powers to verify the genuineness of the claim. That apart, insurance companies like the petitioner in the present case have also enough opportunities in such proceeding to point out before the tribunals in case there is any collusion or in case any false claim is made. It is the duty which is vested in the insurance company, and it is expected that, having regard to the beneficial object of the statute, insurance company will discharge their duties in the true spirit of the Act, so that genuine claim petitions are not frustrated and are disposed of at the earliest, giving at least some solace to the victims of road accidents and family members of deceased. With the above directions and observations, the writ petition is disposed of. So, my lord, in the paragraph number 17, what I have read, if the information pertains to cognizable offense, registration of FIR is mandatory. This is a cognizable offense because there is a collision between two vehicles, and it is highly likely that one of the vehicle is in fault. So in that case, whoever it is at fault has to be taken into account by filing an FIR, which is mandatory in nature as stated herein. So without the registration of FIR, the claim could not have been registered and the claim could not have been taken into consideration. And therefore, I would like to rely on this by saying that FIR, least to say that GD entry is not also permissible in filing claim petitions. In this case, there is no FIR. Therefore, the claim petitions in that regard, in my humble submission, has to be dismissed because of this requirement, mandatory requirements. And secondly, no.
In this present case?
No. No FIR, no GD, no action taken by the police. As we can see from their petition, they have belatedly filed an FIR which was not entertained, and that too after filing of the claim petition.
But does it bar awarding of compensation if there's no FIR?
The trial court has to see as to whether the
exactly the
claim,
trial court has held that they are entitled to compensation. Now, in this case, which is just read upon also, there was a system of just recording in the GD entry and sending the GD entry. Court say that no, simply GD entry will not suffice. You have to send the FIR. FIR has been directed to be sent. But in respect of those pending cases wherein only there were GD entries, court said that it will not be fair to remand it back. So it was directed to proceed in accordance with law. And court also observed that the tribunal also is not powerless to differentiate between a genuine claim and a fake claim. So that's why I'll ask you whether you engaged an investigator, which you normally do. But even if there is no FIR, then you can inquire, because in some instances you used to inquire regarding the financial position. They go to the workshop, they go to the place of work, and I ask, did you actually pay this much? All that. And then they come back and report it. But unfortunately here you have not said anything about that. Person has issued a certificate. saying that 15,000 is the monthly payment to him. Then he himself comes to the tribunal and says that, yes, I pay him this much.
Yes.
What more do you want?
But only on that basis of one piece of paper which he have written and nothing more, that to show that whether he actually paid or not also. There is no proof. He has submitted in this cross-examination also. Apart from that piece of paper, he has nothing more to show. So he has just submitted that I have paid 15,000 and that has been taken into consideration.
But there's no dispute that he has hired him, isn't it, to drive the taxi? You have not led any evidence to the contrary, that he's not an employee of this person and he does not pay him 15,000.
There is no evidence to dispute on that point because no evidence were led in that case. But it's not that we have not disputed, but to dispute we have no evidence to lead in that. Though disputed generally, there is no other submissions which we can dispute it. And the claimant herself in the cross-examination said that there is no photograph of the vehicle which can show at least that the vehicle was damaged in that road traffic accident.
So that's why you used to find out taxi owner, you know, previous owner, you know, and where is it registered, where is it insured, which is the insurance company. They will know because the owner might claim from the insurance company that there's a damage to my taxi. So that's why you're supposed to find out. If you have not done that, that means you're accepting also. If you think that there was no accident at all, then you should at least make some attempt. You are right that they should have filed an FIR. Why they have not filed an FIR, only they will be able to say.
In the absence of FIR, the least we can expect is at least to show some evidence that there was an accident from the claimant's side. For a moment, let us assume that there is no FIR and they were unable to file it. But in that absence, they also have that duty to bring any evidence before the court showing that actually an accident has occurred.
You are the OP number? OP number 4?
In the
claim, OP number 5?
5.
How much have you deposited or paid?
Amount deposited is 50%. It comes around 12 lakhs.
Have you paid any amount?
Sorry? No payment. we have deposited rupees 12,76,500 before this court on
50%.
yes on
And
22nd.
that has been disbursed, withdrawn?
Not yet.
Not yet withdrawn. What is that relevant section which is to be received by the tribunal from the police?
158.
Of the MV Act?
Yes. And 158.
Give me the MV Act.
Yes. One 158.6. Yes. Yes, yes. Even in my book, but this in the
It has been deleted.
the citation of 2019 has taken into consideration of 158.6 again.
So it's surprising it's not here in
Yes,
158.
even by referring to the Supreme Court judgments also, Jay Prakash and all that. This has come from all the, by taking into consideration of the Supreme Court judgment also. This judgment has been passed.
2023 amendment, has it taken away that subsection 6?
2000?
It's not shown in the,
It's not showing in the footnote also.
it's not shown anywhere. But in the 2000 18 edition, it is there.
It is there.
158 subsection is there.
I see. In that case, the 2019 amendment probably has taken away. There was an amendment in the year 2019.
Not in 19, there was an amendment in 2023 also.
23 also, yes.
Can you get a book which is between, after 2018, between 2018 and 2024? It says, as soon as any information regarding any accident involving death or bodily injuries the person is recorded or report under this section is completed by a police officer, the OC of the police station shall forward a copy of the same within 30 days to the tribunal. This is an important question. Anything else to submit?
No, only that much.
Yes,
two issues.
Mr. Johnny. 2 grounds. One is no FIR. Number 2 is that income is not proved.
Lordship, yes. Regarding the accident, Your Lordship, I may take Lordship to the judgment, which is at page C, paragraph number 3, OP number 2. Page C, paragraph number 3.
Yes.
The OP number 2, Rualthan Kuma, contested by filing WS. Rualthan Kuma is the driver of the defaulted vehicle, Your Lordship. That tipper.
Tipper.
Yes, Lordship. Yet contested by filing this WS.
Okay.
And stating amongst others that the claim petition is not maintainable in its present form and style, and that there is no cause of action in favor of the claimant and against the OP number 2, and that he is the driver of the vehicle involved in the said accident, Tata SK 407 EX tipper bearing number such and such. He met an accident with the vehicle. This vehicle is the taxi, Maruti 800 MPI bearing registration number such and such, taxi driven by Lalchandama such and such, which happened on around 28/6/2019 at around 8 a.m. at Phunchong. He sustained a grave injury at the spot, and later it came to his knowledge that on 1/07/2019 he succumbed to his injuries. That at the time of the accident he was holding a valid driving license, and that there is no cause of action against him as the vehicle was validly insured with Tata AIG Insurance Company Limited and having policy number such and such. Therefore, he is not liable to pay any compensation to the claimants in the said accident. Lordship, he is the defaulted driver of the one of the accident vehicle. Then he admitted in his written statement stating that he is the driver of the one of the vehicle, and he met with an accident. Lordship, that he himself clearly stated that, that there was an accident. So no doubt, Your Lordship. And regarding the FIR, Lordship, the incident was reported to the OC Vivacon PS by filing the FIR, Lordship. FIR was trying to lodge before the OC.
When?
Lordship, that was on 6/9/2019.
Why not before that?
Lordship, yes, that's before that. I have interrogated with the claimants and all. Then they say that they directly went to the police station for the said FIR, but they tried to intimate the OC in charge too orally. But they declined that since it is a very belated, so they are not able to entertain that oral submission of the incident. So then thereafter, they have submitted the written FIR, Lordship.
No, when did they go? Immediately or afterwards?
Not after 1.5 months, Your Lordship.
1.5 months?
Yes, Your Lordship.
So question is, why not on that day? After, since you say that the deceased was not at fault. Normally report goes, because police, they always keep record of all the accidents, isn't it, normally?
Lordship, yes.
It's not that they just keep quiet about some accident. It's very strange. Why in this case there was no such kind of, even GD entry also?
GD entry also not available also.
It's not available, isn't it? Is it available?
I think it's available, I think 304A, I think.
GD entry is there?
No, it's, I think it's
nothing.
not available,
Nothing.
304A.
No action was taken by the police in this regard.
No, at least to record some accident happened
Yes,
on this,
yes,
that.
no.
Why it is not entered like that?
Nothing.
This is a very serious thing. Claim compensation or no compensation is a different thing.
Also, yes.
But some incident happens which is not a natural thing. They should also record it.
Yes.
2 vehicles collided, ultimately 1 person died. On your part, did you not try to inquire about the GD entry of that date, of that accident?
No, Lordship.
Simply after how many months?
71 days.
71 days.
Lordship, yes.
You went to the police station to file a report.
Your Lordship, may I clarify one point about that 158(6) clause? The amendment of 2019 has taken away, and in 159, it has come up in 159 now, it seems.
Oh, it's become 159 now?
159. After the amendment in 2019, it seems. As I can go through one judgment of Supreme Court which has dealt. Just now I have found out one judgment in 2022 that has dealt with this type of cases again, by issuing directions, and has clarified that 158(6).
That will be required.
Yes, 158(6) has now become 159.
What is the judgment?
Yes.
Please bring the judgment. You have the citation?
Yes, yes, I'm just.
FIR you wanted to file on which date? 6/9?
6/9, Lordship, yes.
Which year?
2019.
And claim was filed on
5/9, 2019, Lordship.
You have given this judgment Kohar Mohammed.
Yes.
I don't think this is relevant.
I'm just trying to stress regarding 1586 in the operative part in the last page. The operative portion of where the direction will be issued at paragraph number 62 probably in the last paragraph.
Yes.
Accordingly, this appeal is decided with the following directions. In Roman number 2, on receiving the intimation regarding road accident by use of a motor
Just
vehicle.
a minute. Which paragraph?
2, sub number 2.
No, which paragraph? Main paragraph?
Uh,
Okay, yes. According the appeal is decided with the following directions.
Yes, directions.
Yes.
2. On receiving the intimation regarding road accident by use of a motor vehicle at a public place, the SHO concerned shall take steps as per section 159 of the MV Act, Amendment Act.
Yes.
After registering the FIR, investigating officer shall take recourse as specified in the MV Amendment Rules 2022 and submit the FAR within 48 hours to the Claims Tribunal. The IAR and DAR shall be filed before the Claims Tribunal within the time limit subject to compliance of the provisions of the rules.
What is FAR? FAR? Full form of FAR? First accident
First
report.
accident report.
Then IAR and DAR.
Is there in the previous? DAR is damage assessment report.
IAR, injury assessment report.
Yes.
Injury and damage.
Yes. DAR is
Damage.
detailed accident report.
Huh?
DAR is detailed accident report.
Detailed accident report.
Yes.
IAR.
IAR.
Problem is that the police station has not received the report
Yes.
in this case.
IAR is interim accident report. And
Detailed assessment report, detailed accident report.
detailed accident report,
And
interim accident
acci-
report,
accident report.
and FAR.
As per section 159.
159.
Police officer shall, during the investigation, prepare accident information report to facilitate settlement of claim in such form and manner as within 3 months. Within 3 months and containing such particulars as submit the same to the claim tribunal and other agencies as may be prescribed.
Accident report. IAR. Interim accident. FAR is fatal accident report.
Okay, OP number 2 is the driver of the tipper.
Yes.
OP number 3,
Pin number.
first owner.
Yes.
Also, yes, first owner of the vehicle.
There's nothing much to say. OP number 3,
OP number 3 is also
Driver.
contested.
of the tipper.
no, OP number 4. He's not driver.
OP number 4 is
He's the one who bought the vehicle.
Yes.
From OP number 3. In OP number 5 is the appellant, insurance company.
Insurance company.
Insurance company. Yes, yes.
So you are saying that the driver of the tipper also clearly stated that there was an accident?
Yes, Lordship. And besides, Lordship, as per my understanding, there was an FIR, but it was belated. But the problem is there is no police report to that effect, Lordship.
That's the problem.
Yes, yes. Then, Lordship,
Without that, can you get compensation?
As far as my understanding, Lordship, the police report is not mandatory for getting a compensation from the tribunal, Lordship. Since here there are as many as 3 witnesses, and the second witness is the eyewitness who boarded in the one of the vehicle, that is a taxi driven by the deceased. Lordship, he clearly stated that the reasons of the and the cause of accident, Lordship.
So how do you prove that fault?
Well,
You have filed a claim under 166.
Lordship, yes.
You have to prove the fault.
Lordship, as per my
Just
understanding,
by stating that he was riding at the at the far corner of the road, but still he was hit by the tipper.
Lordship, yes. That he's the, Lordship, best witness. He's the eyewitness, Lordship. So, though there is no police report and the negligence is clearly proved, Lordship, by adducing the eyewitness who is boarded in the said accident vehicle.
There were 3 occupants in the vehicle.
Lordship, yes.
The taxi driver who died,
Lordship, yes.
and the other one is the husband and wife.
Yes.
Who appeared before the tribunal?
The husband.
The husband.
Yes. Wife is died after some time when the accident happened, Lordship.
The wife
But
died?
Died, Lordship, yes.
Died of what?
Died of, not because of this accident, other disease, Lordship.
Where is that in the evidence?
Page M. Paragraph 9, Lordship.
9. Paragraph 8 is very long, no?
Yes.
3-4 pages. Paragraph 9.
Paragraph 9.
Yes.
CW number 2, Larin Moya, husband of Larin Omi, late. Larin Omi is the person who is boarded with Larin Moya. Residents of Suampuiluan, Saitul district, Mizoram, aged about, since stated that he is the claimant's witness number 1 and one of the passengers in the accident driven by the deceased Lachandama, that on he hired that deceased Lachandama, that on he hired a taxi bearing numbers as and such driven by the deceased Lachandama from Edenthar to Sairang, and he was accompanied by his wife Larin Omi late. Say Larin Omi late.
When did she die?
Lordship, that was not stated here, Lordship.
But we have to know.
Your Lordship, here the attempt has been made from the claimant side. They have approached the concerned OC since he denied to acknowledge the same and did not prepare the police report, and thereafter they proceeded to the SP ISO for the same purpose. Then, Your Lordship, though we are not able to produce the police report, which
Probably
is
on getting some legal advice. Prior to that, they were not bothered about filing FIR.
yes.
There was no report, nothing. Where exactly did the accident happen?
Your Lordship, as stated by the these claimants, this is the fact.
Where exactly happened the accident?
It's at Punchong, Your Lordship, Punchong.
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 Punchong, which area? Nothing has been stated. This witness which you just read, CW2, when they reach the curve road at Punchong, Punchong area is full of curve road. Curve road number 1 to 100. Which curve road?
And Lordship, I may be allowed to produce some authorities also in this regard.
You have finished your submission or what?
Regarding this non-production of the police report or FIR, I have submitted. And Your Lordship, the second one regarding the this income. So the employer has been produced before the trial process.
Let us complete that FIR thing. You have any authority on that?
Lordship, yes.
So,
2011, 11 SCC, 2011, 11 SCC, 635. Paragraph number 10 to 13, 10, 11, 12, 13.
Read.
Unfortunately, this court finds that the well-considered decision of the tribunal was set aside by the High Court inter alia on the ground that even though the complaint was forwarded to SSP, Senior Superintendent of Police, Hisar, and was further forwarded to SSP, Hanu Magar, but none from the office of SPP, Hamu Nagard, came to prove the complaint. The filing of the complaint by the applicant is not disputed as it appears from the evidence of PW number 3, Satbir Singh, who is the assistant complaint clerk in the office of the Superintendent of Police, Hisar. If the filing of the complaint is not disputed, the decision of the tribunal cannot be reversed on the ground that nobody came from the office of the SSP to prove the complaint. The official procedure in matters of proceedings with the complaint is not within the control of the appellant, who is an ordinary village woman. She is not coming from the upper echelon of society. The general apathy of the administration in dealing with the complaints lodged by the ordinary citizens is far too well known to be overlooked by the High Court. In this regard, the perception of the High Court in disbelieving the complaint betrays a lack of sensitized approach to the plight of the victim in the motor accident claims case. The other grounds on which the High Court dismissed the case was by way of disbelieving the testimony of Omit Singh, PW number 1. Such disbelief of the High Court is totally conjunctural. Omit Singh is not related to the appellant, but as a good citizen, Omit Singh extended his help to the appellant by helping her to reach the doctor's chamber in order to ensure that an injured woman gets medical treatment. The evidence of Omit Singh cannot be disbelieved just because he did not file the complaint himself. We are constrained to repeat our observation that the total approach of the High Court unfortunately was not sensitized enough to appreciate the plight of the victim. The other so-called reason in the High Court's order was that as the claim petition was filed after 4 months of the accident, the same is a device to grab money from the insurance company. This finding, in the absence of any material, is certainly perverse. The High Court appears to be not cognizant of the principle that in a road accident claim, the strict principle of proof in a criminal case are not attracted. The following observations of this court in Bimla Devi versus Himachal RTC are very pertinent. In a situation of this nature, the tribunal has rightly taken a holistic view of the matter. It was necessary to be borne in mind that strict proof of an accident caused by a particular bus in a particular manner may not be possible to be drawn by the claimants. The claimants were merely to establish their case on the touchstone of preponderance of the probability. That standard of proof beyond reasonable doubt could not have been applied. Lordship, another citation is...
No, this was a case when there was a complaint.
There was a complaint, Lordship.
It is not a case that there was no complaint.
No complaint.
There was a complaint, but nobody came from the office of the
Lordship, yes.
SSP to prove. So court said that you cannot, the claimant cannot be expected to be influential upon the SSP, so that to call him for proving, because nobody came.
Nobody came.
But there was a complaint.
But Lordship, in my case also, there was a complaint. It was a little bit belated. But the police personnel did not prepare the...
Complaint is in your hand.
Complaint, Lordship.
Complaint is in your hand. They didn't accept it.
Lordship, yes.
In this case, complaint was there in the
but
office.
Lordship, as per my understanding, I have approached the OC. I have intimated this incident, Lordship. That's...
But you have intimated after so many months.
So many months, yes. That is true, Lordship.
That's quite surprising. Another surprising part is the police also did not keep track about the accident. At least some GD entry should have been there. Yes, another...
Lordship, 2019 to SCC, 2019 to SCC, page 186.
This is regarding?
This is regarding the complaint, Lordship. Paragraph number 15 and paragraph number 20. Paragraph number 15. At the outset, we may reiterate, as has been consistently said by this court in a series of cases, that the Act is a beneficial piece of legislation enacted to give a solace to the victims of the motor accident who suffers bodily injury or die untimely. The Act is designed in a manner which relieves the victims from ensuring strict compliance provided in law, which are otherwise applicable to the suit and other proceedings, while prosecuting the claim petition filed under the Act for claiming compensation for the loss sustained by them in the accident. May I take Lordship to paragraph 20. Keeping in view of the aforesaid mentioned principle of law, when we examine the facts of the case at hand, we are of considered opinion that the claims tribunal and the High Court were not justified in dismissing the applicant's claim petition. In our view, the applicant's claim petition ought to have been allowed for awarding reasonable compensation to the appellants in accordance with law. This we say for the following reasons. Firstly, the appellant had adduced sufficient evidence to prove the accident and rash and negligent driving of the driver of the offending vehicle, which resulted in the death of Rajesra Prasad. Secondly, the appellants filed material documents to prove the factum of the accident and the person involved herein. Thirdly, the documents clearly established the identity of the truck involved in the accident, the identity of the driver driving the truck, the identity of the owner of the truck, the name of insurer of the offending truck, the period of coverage of insurance of the truck, the details of the lodging of FIR in the police station concern in relation to the accident. In our view, what more documents could be filed than the documents filed by the applicants to prove the factum of the accident and the person involved therein? Fourthly, so far as the driver and the owner of the truck were concerned, but remained ex parte since inception and therefore neither contested the appellant's claim nor entered into the witness box to rebut the allegations of the appellants made in the claim petition, and the evidence and adverse inference against both could be drawn. Fifthly, so far as the insurance company is concerned, they also did not examine any witness to rebut the appellant's evidence. The insurance company could have adduced evidence by examining the driver of the offending truck as their witness, but it was not done. In our case also, the insurance company failed to produce any witness to rebut the this claimant's evidence, Your Lordship.
The OP number 2 was not examined.
OP2 was not examined, Your Lordship. He had filed the WS.
He had filed WS only.
Yes, yes. And they have a sufficient chance to produce the witness also, Lordship. And another citation, Lordship, 2021 1 SCC 2021 1 SCC 171.
Regarding?
This is regarding the report of the accident, Lordship. Paragraph number 14 to 22. Paragraph number 14 to 22. Paragraph number 14, Lordship, page 179. May I read, Lordship? It is not in dispute that the accident took place near Gazipur and the numerous people had assembled at the spot. Some bystander would obviously have informed the police also, while the contents of the FIR as well as the statement of AW number 3 leave no room to doubt that injured were taken to the hospital by private persons and not by the police. It is quite natural that the police would also have reached the government hospital at Gazipur, and therefore it was mentioned that Sandeep Sharma was brought in by SI such and such. It is a commonplace for the most people to be hesitate about being involved in legal proceedings, and they therefore do not volunteer to become witnesses. Hence, it is highly likely that the name of Ritesh Pandey or the other person who accompanied the injured to the hospital did not find mention in the medical record. There is nothing on record to suggest that the police reached the site of the accident or carried the injured to the hospital. The statement of AW number 3 therefore acquires significance, as according to him he brought the injured in his car to the hospital. Ritesh Pandey number 3 acted as a good Samaritan and responsible citizen, and the High Court ought not to have disbelieved his testimony based merely on the conjuncture. It is necessary to reiterate independence and benevolence of AW number 3. Without any personal interest or motive, he assists both the deceased by taking him to the hospital and later his family by expending time and effort to dispose before the tribunal. It is quite natural that such a person who had accompanied the injured to the hospital for immediate medical aid could not have simultaneously gone to the police station to lodge the FIR. The High Court ought not to have drawn any adverse inference against the witness of his failure to report the matter to the police. Further, as the police had themselves reached the hospital upon having received information about the accident, there was perhaps no occasion for AW number 3 to lodge a report once again to the police at the later stage either. Unfortunately, the approach of the High Court was not sensitive enough to appreciate the turn of events of the spot or the appellant claimant's hardship in tracing witnesses and collecting information for the accident, which took place many hundreds of kilometers away in an altogether different state. Close to the fact of the case in hand, this court in such and such view, the other grounds on the High Court dismissed the case was by way of disbelieving the testimony of Umed Singh PW number 1. Such disbelief of the High Court is totally conjunctural. Umed Singh is not related to the appellant, but as a good citizen, Umed Singh extend his help to the appellant by helping her to reach the doctor's chamber in order to ensure that an injured woman gets medical treatment. The evidence of Umed Singh cannot disbelieve just because he did not file a complaint himself. We are constrained to repeat our observation that the total approach of the High Court unfortunately was not sensitive enough to appreciate the plea of the victim. In a situation of this nature, the tribunal has rightly taken a holistic view of the manner. It was necessary to bear in mind that strict proof of an accident caused by a particular bus in a particular manner may not be possible to be done by the claimants. The claimants were merely to establish their case on the touchstone of preponderance of probability. The standard of proof beyond reasonable doubt could not have been applied. The failure of the respondents to cross-examine the solitary witness or confront him with their version, despite adequate opportunity, must lead to an inference of a tacit admission on their part. They did not even suggest a witness that he was siding with the claimants. The High Court has failed to appreciate the legal effect of his absence of cross-examination of the crucial witness. The importance of cross-examination has been elucidated on several occasions by this court, including by the Constitution Bench in such and such. Section 137 of the Evidence Act defines what cross-examination means, and Section 139 and 145 speaks of the mode of cross-examination with reference to the doctrine as well as oral evidence. It is precedence of law that cross-examination is an acid test of the truthfulness of the statement made by the witness on oath on examination in chief, the object of which are, Lordship, that may not be necessary, Lordship.
Okay, see, you come to para 6.
Para 6.
There was a police report in this case.
Lordship, may I read?
Yes.
The insurance company in a separate written statement took preliminary objection that as per and first information report, the accident caused by unknown truck which hit up car such and such, and therefore the claim petition filed against the owner or car insurance was contrary to law. Factual averments made in the claim petition were denied for want of knowledge.
So only question here was how it happened, in what manner accident happened. That was the question.
Lordship, yes.
But there was a police investigation and first information report.
And Lordship, that para number 7 here it says that the statement of the eyewitness Ritesh Pandey, AW number 3, Lordship. That's why I read out, and the High Court may not be disbelieve the witness of PW, eyewitness of PW number 3, Lordship.
Okay.
And Lordship, one more citation, Lordship. 2009, 13 SCC, 2009, 13 SCC, page 530. This is regarding preponderance of probability, Lordship. Paragraph number 14 and 15.
Just find out how many cases are.
Paragraph 14 and 15, Lordship. Some discrepancies in evidence of the claimant's witnesses might have occurred, but the core question before the tribunal and consequently before the High Court was as to whether the bus in question was involved in the accident or not. The purpose for determining the said issue, the court was required to apply the principle underlying the burden of proof in terms of the provisions of Section 106 of the Evidence Act 1872 as to whether the dead body wrapped in the blanket had been found at the spot at the earlier hour, which was required to be proven by the respondents number 2 and 3. In a situation of this, the tribunal has rightly taken a holistic view of the matter. It was necessary to be borne in mind that strict proof of an accident by a particular bus in a particular manner may not be possible to be done by the claimants. The claimants were merely to establish their case on the touchstone of preponderance of probability. The standard of proof beyond reasonable doubt could not have been applied. For the said purpose, the High Court should have taken into consideration the respective stories set forth by the parties. Then, Lordship, with this my submission, with this regarding the police report and complaint was belatedly submitted. Though the FIR was not entertained by the concerned police officers, but there was a eyewitness who is not an interested party here in Lordship, and his evidence has been recorded before the tribunal, and the evidence was not shaken at the time of cross-examination also, and there is no rebuttal evidence from the appellant, Your Lordship. Then they have a sufficient chance to produce the witnesses, and they have a sufficient chance to produce the documents which they have relied upon. So that was not done on their part, Your Lordship. So this appeal may be rejected, Your Lordship. Yes. Yes.
We'll see. Mr. Roshan, you had produced this ICIC Lombard versus State of Assam.
Yes.
Which was the paragraph you were relying upon?
Starts from paragraph number 17,
17,
18 and 19.
18 and 19. Okay, ठीक.
I got paragraph number
The column for hearing. That's part hard. That much. This is item 7, isn't it?
Lordship, yes. 8. Item 7, Lordship, it may be kindly taken up after a week.
Okay. Item 7, hearing list, you write, as paid for by Mr. Joniel Tochong, learned counsel for the appellant, and not objected to by the other side. This is the matter, again after a week, for hearing. This is item 8.
Item 8 also, yes.
Okay.